Welcome back to the chat. So as some in New England are still celebrating the fourth Super Bowl victory of the Patriots, a few dozen are back in a courtroom this afternoon as testimony continues in the murder case against former Patriots standout Aaron Hernandez. So Sir Hernandez had a $40 million contract with the Patriots when he was arrested for the murder of Odin Lloyd. Something interesting, the judge allowed jurors in the case to watch the Patriots play in the Super Bowl, but told them to leave the room if Hernandez's name was mentioned. So we're joined now by our legal contributor, Heather Quick. And Heather, lots to talk about here. There's actually some breaking news that happened within the past few hours, and that was one of the jurors was asked to leave, a female juror, because the judge said that that person had an early interest in being on the case. So what does that mean? That that person wanted to write a book or what?
There can be a lot of money. It can be very lucrative to be a jury on the right case nowadays. And both the prosecution and the defense have to take that into consideration, and the judge. I mean, the legal system works when everybody plays by the rules, and there are a lot of safeguards, but I think, the whole, can you get financial motive out of this? And if you have your own motive, and is that going to conflict with achieving justice?
And they don't want to mistrial down the road later to have this come out that it was known that this person had an interest in being on the case, and all of a sudden you have to throw the whole case out because of this.
That's right, and that's why they usually have alternates. And so if you can catch this during the trial, it shouldn't, and before deliberations, it should not mess anything up, because many things happen in a jury trial that, especially, even if it goes on just more than a couple of days, somebody gets sick, lots of things can happen. So, hopefully they just filled in an alternate and are able to not
picked on the trial on purpose, right? I mean, you get this random letter, you end up randomly on a jury.
Haven't you seen Runaway Jury, John Grisham? I mean, yeah, it happens all the time.
Gosh,
no, I'm teasing.
Well, but I mean, how does that happen?
Okay,
I'd rather get on an interesting case than a boring case.
Sure.
Right?
I guess you've been picked, and then you see this as an opportunity. I mean, we do live in, free market society, and you're like, hey, this is pretty interesting. This might work for me. I can't imagine. I think it'd be very difficult to then purposefully put yourself there because it's randomly selected, the pool.
Right.
But once you're there, would you, if you thought, oh, I could see some upside to this, am I going to answer the questions in one way versus another? Jury selection goes on, it can be excruciatingly long.
It's so important, right?
And it's so important, but there's only so many questions you can ask individual people because you've got the whole panel. There's quite an art to picking a jury, and the judge, though, is always in control. So how much are they going to let you ask? How well will they let you delve into it? Because a lot of people do want out. And so they'll just say, well, I can't make a fair decision. They're guilty. And the judge will say, well, what if I tell you to follow the law? Or you'd be in contempt. And then, to keep, it's just quite an interesting process. A lot's at stake.
So first of all, I can't imagine what could cause a person to be so angry that they would lose a $40 million contract.
Allegedly.
Allegedly, right. However, I read somewhere that they wanted his past behavior nowhere in this. Why? Wouldn't that play
germane to the case?
Yeah, I would imagine.
Well, and what do we think when we know that he's been accused of other murders? Then we think, oh, well, he must be guilty of this.
But he wasn't even charged in that.
Well, it's just, where there's smoke, there's fire, as we've said before.
Yeah.
And knowing that, is that going to prejudice him? Absolutely. Now, if it is a similar pattern, there's certain case law that allows the prosecutor to say, like when we have serial killers or serial rapists, and there's a specific past behavior, and we can use that to show a pattern or routine that would be not to say he's guilty of this, but it's similar to the other past crimes, then you can get it in. But our Constitution is there to protect you. You are innocent until proven guilty in the eyes of the law. And by allowing your bad acts, and this goes down from petty theft, priors, if somebody happened to be...
Why are you looking at me?
I don't know.
Allegedly.
Allegedly, or DUIs.
Oh, no.
Things like that, because you would automatically be like, oh, well, they've done it before. They more likely than not have done it now. So we need to protect those who are on trial, so you have a clean case, doesn't get overturned on appeal.
Yeah, so we were talking about the jury a second ago, and I don't know if they're going to replace this female juror that was just kicked off with another female, but there's a lot is being made of the female makeup of the jury, and there was a CNN anchor who's getting a lot of attention for something that she said about the trial, and actually she was sitting, I think, with a former prosecutor or defense attorney on the panel, and she speculated that with the makeup of the jury, more women than men, that whether or not they would, quote, convict somebody who is handsome. So take a listen, watch, and we'll talk about that.
There has been much made of the makeup of the jury. Lots and lots of women on the jury. And some say that'll help Aaron Hernandez because he's a handsome guy. There's no clear motive for why he would murder Odin Lloyd. And maybe they'll take into account there's a handsome guy with a fiance and a kid and a $40 million contract. Not possible that he shot someone.
I got to tell you, I am really fascinated by this case, but also troubled by the prosecution's case. As a former prosecutor myself, I know that you don't have to prove motive. It's not an element of the crime. But each and every juror is going to think exactly what you're saying. You know, well, he had $12.5 million guaranteed. This is a guy who was successful. He's good looking. He's got this fiance. He's got a family. Why on earth would he do something like this?
So do you think that she said every woman would think this, that he walked out on a $40 million contract? Why would he do something like this? He's a good-looking guy. He's got the good-looking fiance who's sitting there with him. What do you think about hearing that?
Well, I think men would think that too. Don't we all think that? Like, you know?
And they also brought attention to motive.
But then I think, I mean, what? Women aren't smart enough to listen to the law and make a decision, and we're going to be distracted by a pretty face or a good-looking guy. I just think that's very, you know.
And what do you think about the no motive, no weapon found? I mean, those are, and we talked about the evidence. Some of it has been banned, some of it's been allowed. Like there's a marijuana blunt that has his DNA evidence on it, a shell casing in a rental car that he had, a footprint that matches the sneakers at the crime scene, home surveillance video outside his home with allegedly, I think Odin Lloyd was in the car with him, text messages. So, but a lot of people are saying that there's still reasonable doubt. They don't have a weapon, they don't have a motive, they weren't there to see anything happen. None of the witnesses who were there are apparently saying anything, the co-defendants.
Right, yeah.
So, I mean, is this really like a slam dunk case that a lot of people think it might be?
Well, there are more cases that have been built on circumstantial evidence. There's not always anyone there. Sometimes the motive is not ever known. It's just there's so much circumstantial evidence that's like, well, could it be another? Is there another explanation? And that's the job of the prosecutor. If they did not take cases that didn't have a clear motive or admission or eyewitnesses, we would never prosecute anyone. Be a very small percentage. And they have a hard, heavy burden to prove. Obviously, a lot going against this guy. I mean, a lot to say, well, why would he do this? But there's also that he's making all this money. He doesn't think he's going to get caught as well. A lot to do with that ego. I mean, you got to have a huge ego to play football and succeed. You do. And to know you're the best and to make that kind of money. And so let's just consider that. He probably thinks he's better than the rest of us anyway, and is not going to get caught. And he can afford the better attorney.
Yeah, well, we'll be following this, and we'll have you back on as things develop in the case. Okay, another story we wanted to get your take on. It's been in the headlines, the conviction of 2 ex-Vanderbilt football players who were found guilty of raping an unconscious 21-year-old girl. The attorney for one of the convicted men is calling for a mistrial after learning that a member of the jury, was a rape victim. How likely is it that the discovery of this will overturn the case and that this is going to go anywhere? And
this is unfortunate for the prosecution and for the victim. I mean, we got to say, that was not an easy trial to endure, and there are still some other co-defendants out there to be tried. I think it's problematic for the prosecution and the judge. It's up to the judge. Does it rise to the level of a mistrial? And that is what he's going to be looking at. Again, protecting the defendants, and I know we get sick of hearing that, but that is the way the law is, and it's important that the rules are followed and their constitutional rights are followed within that trial. I think it's going to be a very difficult decision, but there's so much overwhelming evidence. So that's what we have to look at. Okay, was the evidence so much so that wouldn't have influenced it? But you have to have a unanimous jury, and so in
Heather, I've sat through questioning. I've been, pre-selected for a jury and went through the questioning, and they do ask a lot of very personal questions. I remember sitting there saying, "Has anyone been arrested?" And people had to raise their hand. Yes. So could that have been a situation where they asked that question and this lady didn't want to share that information? Yeah. What recourse would she have had? Can you go to the judge or the attorney after and say, "Hey, I didn't want to share this in front of everybody. I was uncomfortable." I just can't imagine why she wouldn't have disclosed that, even if she didn't want to do it publicly.
Yeah, and they do. It depends on what the process is. There should be an opportunity to say, if anyone needs to talk with us privately, please let the bailiff know, let someone know, so that there can be more of a confidential conversation. And it's difficult. It's one thing to be a victim of a crime, and usually they're going to ask that because that's important for the defense to know, because if you've been a victim of any crime and now you're on a jury, are you going to be, you know, less sympathetic? How are you going to think of your case when you're hearing the evidence and not listening to the evidence separate from yours? It's very hard with personal experiences. And so I think it's going to be problematic, because if they find out, I think the one thing said they did fill out either a sheet saying if you had been a victim or involved in the criminal justice system at all. And if she answered no, you know, I mean, even maybe she's thinking, well, it wasn't a court case. You know, I don't know. I don't know. I think we're going to probably find out more facts, and it's just very difficult, and it's terrible. They should have found that out in the beginning, you know, and I do think that is the responsibility of the defense and prosecution. So then if she lied, you know, I mean, they're going to have to, I think, do something to make sure it's right for the defendant so that they have a good conviction.
Dartmouth College just announced that they're banning hard liquor on campus. What do you, first of all, will that work? I mean, is that some sort of, I don't know, plea to the students that this is the reason for all of this activity that's going on, not just at Vanderbilt or, I mean, it seems to be everywhere.
Don't you think we talk about this all the time?
All the time.
Yeah.
The violence and sex and
Yeah.
alcohol
And is
on
that
campuses?
legally enforceable? Can they do that?
Well, absolutely. It's a, you know, it's private property, you know, and certainly within the halls that are, you know, things that are on campus. So those resident halls, which it probably is, it's going to apply more to the fraternities, sororities in those areas, and not allowing hard liquor. Can they enforce it? Yeah, they're going to probably end up having to shut down a lot of parties and things like that. It's going to be difficult. It's going to be difficult. That's why many colleges do not allow the fraternities and sororities to be on official campus property, because they don't want the liability.
Of course.
They want to wash their hands of it, nor do they want to supervise it and protect the students.
All right, Heather. Well, thank you. We appreciate your legal expertise as always. And if you have any questions for Heather, you can always email her. I'm always curious, what kind of questions do you get as a result? Because I say ask her anything.
I know you do.
When I throw that out there, what actually comes across your email desk? Maybe we'll get into
Penny
that one
may be
day.
calling me later.
Yeah, I
I'm
was
going to
gonna
tell
say,
you.
wow. Again,
Allegedly.
You admitted it.
we always have that video evidence we can come back
Absolutely.
to. And then we have our garage, and then we'll get some pictures. It'll be great. No, I'm just kidding. All right, Heather, your website is thequicklawgroup.com. All right, thank you as always for being here. Weigh in. We'll be right back, coming up right after the short break.